Greetings, my name is David Petrosky. I'm a California attorney and I represent landlords with eviction cases. In a previous video, I discussed AB1482, which is also known as the Tenant Protection Act of 2019. In that video, which you can view on this YouTube channel, I provided an overview of AB1482. In this video, I'm going to be discussing exemptions to the Tenant Protection Act of 2019. But first, I want to give you a little bit of a disclaimer and let you know that the landlord-tenant laws in California are in flux. They change relatively frequently these days, and by the time you watch this video, the laws could have changed. Thus, it's very, very important that you seek out your own legal counsel for each of your own individual cases and do not rely on this video as legal advice. Additionally, the California landlord-tenant laws can seem deceptively simple, but they're not. They are quite complex, and even a single mistake could cost you the case. With that disclaimer out of the way, let's dive right into the Tenant Protection Act of 2019. The Act has two different parts to it. One talks about eviction restrictions that require a just cause reason to evict, and again, that was discussed in a different YouTube video. And then there's rent caps. Rent caps were not discussed in the other video. They're not going to be discussed in this video. This video is going to be focusing on the exemptions to the just cause requirement under AB 1482. The most common rent control exemptions under the law are going to be outlined herein. Not every single exemption is going to be discussed, but I want to point out the most common exemptions to the law. It's also important to note that the just cause restrictions begin to apply once a tenant has continuously and lawfully occupied a residential real property for 12 months. So what does that mean? If the tenant has been in the property for less than 12 months, the just cause rules are not applicable. It also means that these restrictions apply only to residential real property. Commercial properties are exempt. One exemption to the just cause eviction requirements under AB 1482 is housing accommodations in which the tenant shares bathroom or kitchen facilities with the owner who maintains their principal residence at the residential real property. In other words, if the owner/landlord lives in the same house as the tenant, then under these requirements, if the landlord and tenant share bathroom or kitchen facilities with each other, and the landlord lives in the property as well as the principal residence of the landlord, then the rules don't apply. Another exemption is for single-family owner-occupied residences, including a residence in which the owner-occupant rents or leases no more than 2 units or bedrooms, including but not limited to an ADU or a junior ADU. So if the owner occupies the residence and he rents out no more than 2 bedrooms or units, then that would be exempt. Another exemption is for duplexes in which the owner occupies one of the duplex units as the owner's principal place of residence, but the trick here is that the owner needed to occupy one of the units at the beginning of the tenancy and remain in occupancy throughout the entire tenancy. So remember here, the owner needs to live in one of the duplex units as his principal place of residence, and that occupancy needed to be in place at the beginning of the tenancy and remain in place throughout the tenancy. Another exemption is for housing that has been issued a certificate of occupancy within the previous 15 years. And this is a rolling date. So what this exempts is for any new construction that's been in place within the past 15 years. So whatever date you want to begin the eviction, you count back 15 years, and if the property was built within the past 15 years, then it's exempt. And remember, this is a rolling date, so every year you're going to have to increase the date by 1 year. This next exemption is going to apply to a lot of small landlords, but it's a little bit complicated. And I'm not going to go through this word for word with you. You can read it yourself. But to sum it up, this exemption applies for single-family homes that's separate from the title to any other dwelling unit, provided that two requirements are met. Number one, the owner can't be a real estate investment trust, a corporation, or an LLC in which at least one member is a corporation, and the tenant needs to be provided with written notice that the property is exempt from this section, and there's specific language that needs to be used. So again, this is for single-family homes that are owned by individuals, that are not owned by a real estate investment trust, a corporation, or an LLC, in which at least one member is a corporation. So again, this exemption is for single-family residences that are owned by individuals, so long as the landlord gave the proper notice to the tenant. There are specific time frames and deadlines of when that specific notice must be given to the tenant. Another exemption is if there is a local rent control ordinance that requires just cause for termination of the tenancy and that was adopted before September 1st, 2019, so long as the local just cause ordinance is more protective than AB 1482. So for example, if your property is subject to the Los Angeles Rent Stabilization Ordinance and the RSO, then the property would not be required to go by the rules in AB 1482, but the rules of the RSO would apply. In sum, what does all this mean for landlords? Well, a couple of different things. If your property is exempt from the just cause restrictions under AB 1482, then you're in luck. Congratulations. You're one of the lucky ones, and the old rules continue to apply, meaning that you can evict a tenant for any lawful purpose, and you don't need to provide a just cause reason for the eviction. However, on the other hand, if your property is not exempt, then you'll have to comply with all the just cause eviction protections, and failing to do so will likely cause you to lose the eviction case. So it's very, very important up front before you begin the eviction process. You need to first make the determination whether or not your property is subject to the just cause eviction restrictions under AB 1482, and if it is, you would want to act accordingly. Another important thing to note is that the just cause eviction requirements cannot be waived even if the tenant agrees to waive those restrictions. They cannot be waived. If you want more information, go to our website, which is attorneydavid.com. Again, that's attorneydavid.com. On that website, you'll see an evictions blog with a lot of helpful landlord-tenant information. There's some forms on there for landlords to download. I also encourage you to follow us on Facebook and on Twitter. Subscribe to our YouTube channel. And if you're located within our service area, which is primarily LA County, Ventura County, some of Orange County, and Santa Barbara County, if your case is one that we would be able to assist you with, we offer a free consultation. On the other hand, if it's a case we cannot assist you with, or if you're outside of our service area, we do offer a paid consultation. And if you go onto the website, again, attorneydavid.com, there will be a form to fill out for that consultation. Thank you so much.